Well, as far as the Chief Justice's decision to constitute an 8-member bench to hear the constitutionality of the Supreme Court Practice and Procedure Bill is concerned, there are three fundamental issues with such constitution. First of all, we see that judges who have recently expressed their concerns about the Chief Justice's unfettered and unbridled power to constitute benches, such judges have been excluded from the hearing of this case. So, for example, we see that judges like Justice Yahya Afridi, Justice Athar Minallah, Justice Jawal Khan Mandukhail, all these judges whose views have differed with that of the Chief Justice in the recent past have been excluded from the hearing of this case. So, such constitution of benches to the exclusion of judges whose views have differed with that of the Chief Justice raise concerns about the Chief Justice exercising his powers as a fiduciary of the people, and such constitution of benches raises concerns about the court's ability to act as a neutral arbiter of the law. We have seen that judges have in the recent past also raised concerns about the power to constitute benches being exercised in a manner that dampens an alternative viewpoint. And I think such concerns are aggravated and accentuated when the Chief Justice exercises his powers to constitute benches in this manner. The other issue that is also of fundamental importance in this case is that the Practice and Procedure Bill is still a bill. The Practice and Procedure Bill has not attained finality. It has not attained the status of a law as yet. So any challenge thereto is perhaps not ripe for hearing as yet. But the manner and the alacrity with which the court has shown to hear a challenge to this bill also raises concerns about the court's impartiality, particularly because this bill regulates the powers exercised by the Chief Justice. And perhaps this bill and the manner in which this hearing has been scheduled, it also raises concerns about the court being recalcitrant when it comes to matters of its own accountability. And it also perhaps raises concerns about the court shunning any attempts to make the court's own procedures and practices more transparent. The third and final issue, which I think is also of paramount importance over here, is that Article 4 of the Judges' Code of Conduct states that a judge may not hear a matter which involves the personal interest. But nonetheless, we see that the Supreme Court Practice and Procedure Bill regulates the powers of the Chief Justice of Pakistan. So perhaps it would have been more appropriate and more proper to not include any judge set to serve as Chief Justice Pakistan during their tenure. So judges like Chief Justice Bandial, Justice Qazi Faiz Isa, Justice Ijazul Ehsan, Justice Mansoor Ali Shah, Justice Munib Akhtar, and then Justice Yahya Afridi, Justice Aisha Malik, and Justice Shahid Waheed should have perhaps been excluded from the hearing of this bench. And the Chief Justice perhaps should have constituted a 7-member bench to hear this case, comprising judges who are not expected to serve as Chief Justice Pakistan during this tenure. But these three issues, the fact that the Chief Justice has excluded judges who have disagreed with him in the recent past, and the fact that this bench has been constituted before this bill has attained the status of a law, and the fact that judges who will at some point serve as Chief Justice have been included in the hearing of this case raise a lot of questions about the court's credibility. And we know that the judiciary does not command the purse or the sword, and the only weapon in the court's arsenal is that of its moral credibility. Decisions like this perhaps erode the court's credibility. So as a result, the chasm that has developed between the judges of the court would perhaps only accentuate after this case, and the tensions between the executive and the judiciary would also only increase with such decisions.